Good morning, good afternoon, good evening. I'm Patriot Smoothie here to talk to you to summarize day 32 of the trial of Tamara Lich and Chris Barber. That's right, it's been 32 days of this. I believe that this is the longest mischief trial in Canadian history, and it's still going on. It's still going on. But the good news was that the Crown made that their last submission in reply to the defense's request, the defense's motion to dismiss the Carter application that the Crown is bringing, and of course the Carter application where evidence against one of the co-accused, Tamara Lich, would apply against the other co-accused, Chris Barber, and vice versa. And the Crown had very little to say this morning to finish up their position on the defense's motion to dismiss it. They basically said that there was some text messages between Chris Barber and Pat King where Chris Barber said something about blocking things, and that he was the only person that Chris Barber or anybody actually ended up separating themselves from. Stay tuned to the end because, as always, it's going to be a little bit long and there's a lot of information to cover, but I want to know what you have to think, so please let me know in the comments. I do read them. I'm very busy, but I do read them. Please like the video. It helps a lot. Subscribe to the channel. It helps me get the message out to more people. So there's a couple specific things to talk about, but basically the route that the defense took was, it was Eric Granger up on reply first. So originally the defense teams made their submissions, then the Crown made their submissions, and now the defense is replying to the Crown's submissions. And I believe that Justice Perkins McVeigh said yesterday she'd allow the defense a little bit more open-endedness in their reply because of the nature of the Crown's submissions. They're constantly changing of the furtherance arguments, the second rung of the Carter test. So that's what they did today. And in summary, Granger approached this surgically and methodically. He went against, he dissected the Crown's position on the particulars, specifically basically how the Crown said that it wasn't an accident that it was there, about how it kept changing, and he addressed how each of those things. And the moral, I think, of his argument was that the onus is on the Crown to prove that the defense are guilty, that the accused are guilty of the crime, and they're not doing that. They're making a lot of inferences. They're asking the Crown's asking the court to make a lot of inferences which just couldn't reasonably be made, and certainly not proving things beyond a reasonable doubt. So Granger started off by saying that he believes that the directed verdict approach to this situation, to dealing with the Carter application, is still an option. This directed verdict standard, and I believe also he was arguing that it should be a more limited version of that test to dismiss the Carter application. The Crown said that they wanted to maintain their, and Miss Magus also rised early on to say that she got something late last night, as per usual, 10-something o'clock in the evening, I think in response to Justice Perkins McVeigh's instructions that the particularized request from the defense be answered by today, and so they sent it very late, so they did do it. And Miss Magus basically said the Crown told her that they want to reserve their right to change their application as they go forward, and Miss Magus said to the court that she wants to know, she has the right to know, what case she has to meet as the defense. What are they bringing forward? So there was an adjournment, a break to allow the defense and the Crown to talk about that. They came to an agreement on how that was going to go forward, and that's when Mr. Granger began and said that he believes the directed verdict standard is still relevant here, still applicable. So let's go through a couple of the particular things that happened. So the first thing that happened is Granger rose to talk about the 5 gaps in the Crown's arguments. Gap 1 was the Crown that is treating the events as a single, ubiquitous protest. Example 2 is the Crown is failing to grapple with the presumption of innocence. The onus is on the Crown to establish that the protest was unlawful. 3, the Crown rests on oversimplification of evidence. And as always, thank you TDF Canada, the Democracy Fund Canada, for providing this courtroom reporting to us, so we can know what's going on in there, and hopefully I can be in there again in the future. I don't know when the next date is. I think on December 7th. December 1st is today. December 7th, they have 1 hour set aside for Miss Magus to finish her submissions. A little bit of a plot, a bit of a teaser there, a spoiler of what's to come. Miss Magus did not finish hers, but she made a couple of good points. So continuing, example 4 of the evidentiary gaps that Mr. Granger is presenting to the court, he says 4 is the Crown treats the objective of ending mandates as the common unlawful design when that's not what makes it unlawful. It's the chosen means that, of course, the Crown would have to prove those chosen means were unlawful. And 5, that the Crown wrongly rests on the premise that if Lich and Barber were working on anything together, it was to further a common unlawful design. So the fact, we can look back to the evidence presented in the submission made by the Crown yesterday, where they tried to present a picture of Tamara Lich standing outside, and I joked, you know, call an Emergencies Act, because how dare she stand outside? It's like if they do anything at all, it was inherently illegal, but they haven't proven that. The onus is on them. The responsibility to prove guilt is on the Crown, is on the prosecution, right? And you have a presumption of innocence, which I have to agree with Eric Granger that it doesn't seem like Tamara Lich and Chris Barber have been afforded that presumption of innocence in a lot of these submissions. Basically, there's this kind of feeling that there's this presumption of guilt, that their presence is inherently unlawful and not allowed. All right, so going on to another particular, the Crown says that the absence of violence doesn't make it lawful, and the fact that it's peaceful doesn't make it lawful. Again, so Eric Granger says that it's true. Just because something's peaceful doesn't make it lawful. But again, the onus of proving guilt is still on the Crown. It's still there. And then the Crown continues to say, so Granger replies that the Crown said that it's illegal to obstruct roadways. And then Mr. Granger said that, yeah, that's true, but they're oversimplifying things here, especially when these actions can be criminal, but only if they're done wrongfully. And in this case, police told them how to come in, where to park, where to go. East Convoy goes this way. West Convoy goes down these roads and parks at this place. You know, Southern Ontario Convoy comes in this way, using this highway, comes in on these roads and then parks at this place. So what are you talking about here? How's that common unlawful design when they're working in concert with the police, when they've run their plans through the police and they're doing the plan to come in and park, as the police said? And Justice Perkins McVeigh added that is why she asked the Crown about this in respect to police planning and getting them where they were parked. And now moving ahead a little bit in things, because I've chosen the most interesting things to reply to keep this video down a little bit in the time-wise, because it's been a long weekend. I know we're all tired, and I want to focus on the important parts of what's actually happening in there. Again, Mr. Granger maintaining that the directed verdict standard is the one that should be applied in the judge's consideration of dismissing the Carter application from the Crown. And you know, the Crown trying to say the whole time that they reserve the right to change the footing of their application, more or less, is what I'm interpreting from what's being said. And Miss Magus contending that no, actually the defense has a right to know what case they have to meet, whereas the Crown trying to change it every step of the way until the very last minute. Anyways, so Granger turns to specific Crown submissions, and he references the statement. So at this point he's now going through what the Crown actually said and making specific arguments based on that. So the Crown said, what was seen in the streets of Ottawa doesn't happen by accident. And so that was, you know, what was seen in the streets of Ottawa. People were parking, there was community food, barbecuing, people holding signs, chanting slogans. There was a couple of bouncy houses, there was street hockey and other activities, music from time to time, and whatever else the things people have said they've done. There's a lot of... Don't just take the evidence as word for it. Go and look at the live streams. There's like hundreds to thousands of hours of live streams where you could look methodically through different days of the protest and see good samples of what was happening beyond one person's, you know, verbal testimony. You can actually look at video and see it for yourself. And in any case, Granger replies to the Crown saying that it didn't happen by accident, by saying that even if that wasn't the case, the fact that it's not an accident doesn't make it an unlawful design. Just because something doesn't happen by accident, because it's deliberate, doesn't make what's happening inherently unlawful. And that's very true. That's, again, the onus of guilt, of proving guilt, is on the Crown, and the presumption of innocence is just something that the Crown seems to be really struggling with in this case. It's not being afforded to the accused at all. And the way that the submissions are being presented, there's just too much of evidentiary gaps. There's too much inferences being required of the court to try to come to these different conclusions of guilt. So going on, regarding another submission where the Crown says that multiple convoys doesn't necessarily mean multiple purposes, Mr. Granger says that even if there was a commonality of purposes, there was no evidence of collaboration between multiple groups to amount to a common unlawful design. That's very important. Again, you can't just have the fact that they were there not by accident. You have to have proof that they're doing something inherently unlawful between themselves, especially in this case with the Carter application between Tamara Lich and Chris Barber. And that was literally what Mr. Granger spent a lot of his time on, by saying that the things that Mr. Barber said, the things we talked about briefly yesterday, the blocking the city or causing problems for the police, even though those were in frustration, and again, we have to look at his actions and listen to the police testimony where police officer Botch, Officer Blondie said that he was always amenable, Mr. Barber was always amenable and always cooperative in working with police. But we look at those statements that Mr. Barber sent in frustration to other people, and we compare them to what he actually did when he was trying to reduce the footprint, trying to move trucks out of residential zones, and most importantly, he's not sending those communications to Miss Lich at any point. So the agreement to the common unlawful design, he's not even sending these vent texts, if you want to call them that, to Miss Lich. And there's large gaps of time where he's not sending anything to her at all. And they're the co-accused. There has to be the common unlawful design and the agreement and the furtherance of that between the two conspirators, the co-accused. And there just doesn't exist. It just doesn't exist. And then in another statement, the Crown says there was an idea that morphed into what we lived through. It's interesting that the Crown uses the term what we lived through in this, okay? So what we lived through in January and February, Mr. Granger submits that this shows an evolution at some point. And by the way, the thing about the interesting use of the word we, that's me adding context. That's not something that was said in court by Mr. Granger. So Mr. Granger continues, what we lived through in January and February, quoting the Crown. Granger submits this shows an evolution at some point, and the court would have difficulty determining the design if the plan continued to evolve. Basically, if it's changing, the initial unlawful design, which was never proven, and the agreement between the parties about that unlawful design and the furtherance of that unlawful design, if it's constantly changing, also adds a layer of doubt and complexity to proving the rungs of the Carter application, is basically, I believe, what's being said here. Mr. Granger continues to say that further statements by Lich saying, hold the line, stay here, remain peaceful, and then he goes on to say that there is nothing unlawful that can be inferred by these statements, where she's saying, hold the line, stay here, you know, be peaceful. There's nothing inherently unlawful about those statements. Going on, Mr. Granger briefly touching on Mr. Barber's statements where he made it to Officer Botch. I believe that was about the slow roll or whatever else they were talking about. And Granger continues that the Crown advanced this in their submissions as evidence of furtherance of the common unlawful design. Granger says that if these statements are made to a police officer, it does nothing to move the common unlawful purpose forward unless there is a suggestion that Officer Botch and Officer Blondie were party to the common unlawful purpose. Think about it. He's running these things by the police, talking to the police. So if he's engaged in a common unlawful design, a mass conspiracy, and he's advancing this while telling everything he's doing to the police, then that makes no sense unless the police are party to the unlawful design. You got to think about that a little bit more clearly, I think. Now, Ms. Magus coming in and saying, pointing out that the Crown submitted that there is an absence of violence is only an aggravating factor. And Magus goes on to say that she differs with the Crown here because an unlawful assembly only becomes unlawful if the peace is disturbed tumultuously. And Ms. Magus had the law to back it up. She says that this is an objective standard per Section 65 and Section 66 unlawful assembly of the Criminal Code. There must be a reasonable fear that the peace will be disturbed tumultuously. Essentially, this is commentary by TDF here in parentheses, essentially erupting to the level of a riot. And there's very strict definitions of what that is and what the criteria are, what the onus of guilt proving is on the Crown, and basically that there has to be violence to make this an unlawful assembly in that way, or tumultuous activity where people are reasonably fearing and not just upset because they see people who are not wearing whatever, right? So we got to look at that in two ways. Magus turns to January 9th statements, so we don't have to look at that in two ways. We have to look at that through the lens of a tumultuous activity where reasonable people are having reasonable fears. And, you know, we saw families, we saw Canadians of every background and origin and belief in the convoy participating or existing at least peacefully without being disturbed or attacked. Or there was no examples of that people can find of violence erupting or anything like that. So Magus goes on to a January 9th statement of Barber about a slow roll, and she says that the Crown goes too far in claiming that this forms an unlawful purpose. Magus adds that this would apply pressure to the government, certainly, but we have strikes in this country recurring right now which cause inconvenience and apply pressure to the government. Just because you're applying pressure to the government by protest doesn't make it a common unlawful design. And she continues that picket lines obstruct with the production. Well, we can go through that. She says that the evidence only shows messages of planning between Barber and individuals who are not Lich, I believe referring to the January 9th messages, and that is requirement of the Carter application to show an agreement between Lich and Barber. So if Barber is saying stuff to other people that doesn't go and serve as a furtherance or a proof of the agreement between Tamara Lich and Chris Barber to engage in the common unlawful design and to push it forward, it doesn't do that. And the last one was where Miss Magus was turning to the Justice McLean injunction, I believe of February 7th and February 16th, the Horn injunction, and Miss Magus said to relying on the wording of the verdict where individuals remain at liberty to peacefully protest, she asked that the court review the entire transcript of the hearing, I assume, for context. The Crown disagrees and says that and asks that only the ruling be provided to her honor. And that was it for day 32. Again, there were going to be something for 1 hour on 1 p.m. on February 7th, I believe, and I'll try to cover that to the best of my ability. At the very least, I'll make a summary video, and just to try and circle back to the beginning to make sure I was correct about the things said about Pat King, blah, 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 blah. So the Crown message references a text message that Barber sent to Pat King, which stated, "We need more trucks to block them in." Okay. The Crown states that this goes to a common unlawful purpose. Again, Pat King is not Tamara Lich, and I believe at different points there was attempts to separate publicly from Mr. Pat King for one reason or the other, and that it was clear at different points that there is a lot of protesters in the protest who were not there under a single command and control structure. Anyways, from Ottawa, thank you. That was day 32 of, I believe, the longest mischief trial in Canadian history. Let me know down below what you're thinking. Leave a comment, like the video, subscribe, and I'll see you next time on Patriot Smoothie.